What makes a case appropriate for mediation? That's our topic for Justice Thursday. And we are joined by Mr. James Mangerere. He is a senior advocate of the High Court and the president of the Mediation Training Institute, East Africa. James, good morning.
Morning, everybody.
Karibu sana wakili.
Yes.
What's the difference between a senior counsel and a senior advocate?
Well, senior counsels usually they apply. There's a criteria where people apply, and they are vetted, and then they are conferred that position of senior counsel. The senior advocate is a person who has practiced for so many years and has experience, but has not applied for that particular position. Yeah.
Okay.
Yeah.
How many years do you need to serve to call yourself a senior advocate?
Well, for me, I've gone more than 23, 24 years now. And so I believe if that terminology, senior, means that a number of years that you have been in practice, I think I qualify to be in that position.
Karibu sana senior.
Yes.
That's the hot seat of the Situation Room.
I'm ready for that.
We've been on air for how many weeks now? More than 50 episodes. We have been here for more than 100 episodes. So we are the senior show on radio and TV and online.
1,000 actually.
Yeah? Many.
Easily 1,000 plus.
Many. 52 weeks times 4. Okay? I have the day's proverb. Our senior City Muga is not in today. He's working remotely. And so he left me the proverbs. The proverbs for this week are from Zimbabwe. Have you been to Zimbabwe? Have you trained mediators in Zimbabwe?
I've trained in Zambia and in Malawi. I'm planning to train in Zimbabwe.
Okay.
Yeah.
So the Zimbabwe proverb, when you go there, they'll give you this proverb. And we want you to give us your interpretation. Now, this one is clearly a very direct translation from whatever language they said it in Zimbabwe. So we are translated into English. When you hear it, I'm sure you're going to translate it directly into your mother tongue, and then you'll understand.
I do so.
What is impossible is impossible. You cannot remove pregnancy by coughing.
Well, I think what that means is that if you want anything to happen, you have to do something about it. So you can't wish things to happen. You know, sometimes we find ourselves in helpless situations where every time we are in such situations, we want somebody else to help us. So I think that proverb tells you that you must do something. Mtaka ja mfunguni, sharti ainame.
Kabisa.
Yeah.
Mtaka shambunguni. That one you've heard at least, Ndu.
Ukitaka shirti?
Sisha. Ukitaka shati inama. Sawa. Let's leave it at that. Okay?
Okay.
Yeah. Senior advocate, mediation. We have had conversations here, on alternative dispute resolution mechanisms. Very many of them. We talk about mediation, we talk about arbitration, we talk about all this. What is mediation, and how is it different from the others?
Mediation is an alternative dispute resolution process. In fact, the word mediation means assisted negotiation. Among those that you have just mentioned, in alternative dispute resolution systems, we have negotiation, followed by mediation, followed by conciliation, followed by medi-up, where you do mediation and follow it with arbitration, followed by abmed, followed by neutral evaluation, followed by adjudication, mini trial, arbitration, and then the extreme now is litigation. All those are alternative dispute resolution processes. Yep.
Hey.
But mediation itself appears to be the best because you allow parties to make their own decisions. All these other processes like arbitration, there's a third party who listens to you and then decides for you, makes a ruling, a judgment we call an award. The same thing with the litigation. Arbitration is a quasi-judicial process. In fact, we call arbitrators private judges because they listen to you, they examine evidence and make decisions. In mediation, the reason why mediation is powerful is because you empower parties to make their own decisions, and they tend to respect those decisions more than those decisions handed over by a third party who may not be in a position to understand the substratum of the dispute.
Okay.
Yeah.
So how is that different from negotiation?
Now, negotiation is where two parties engage directly with each other, trying to persuade each other. You give me something in exchange for something. When these negotiations fail, when lines of communication now are closed, a third party who is neutral comes in to assist the two parties who have been negotiating to open lines of communication and assist them to arrive at their own mutually acceptable solution. That's the difference.
Okay.
Yes.
And conciliation?
Conciliation is where a third party proposes a solution. You see, in mediation, a third party does not propose a solution. They assist you to come out with your own solution.
Okay.
But in conciliation, just the same thing Kofi Annan did when he came here in 2007. Kofi Annan did not mediate. What Kofi Annan did, he came with a solution. He said, well, to settle this post-election violence, I think these people require a coalition government. And so he came with that idea. He placed one group at the Serena Hotel, the other one in State House. So for him, he was moving between them in what we call shadow diplomacy, trying to sell to them his own idea. So he was proposing an idea that you can only settle this through a coalition government.
Okay.
If eventually he managed to convince the parties to buy into his idea, by the time you were seeing the two protagonists greeting each other at the Rambe House, Kofi Annan had succeeded in selling his idea to them. Yeah, exactly. That's what conciliation is.
Okay.
Yeah.
I just want to hold on to conciliation for a minute.
Yes.
Because what we're essentially saying here is that mediation gives both parties an opportunity to speak their mind.
Yes.
The third party, however, does exist in mediation because that's the person who kind of, sews everything together. Is it not? The mediator.
The mediator, yes.
Now with the conciliation, the third party, it's their idea.
Yeah.
And but what is established is that there are two warring sides, isn't it, already?
Exactly.
And they've not been able to come up with an idea. So the conciliator comes in with an idea and brings them together.
Exactly. It is also, this third party is also neutral.
Okay.
The third party, the process is also voluntary. But the third party works very hard to convince the parties that the solution to their problem is this. So they propose a solution and then they sell it to the parties, which is totally different from mediation, where you allow parties to come up with their own solution.
Okay.
Yes.
Is there any kind of egging on that happens by the mediator? Because we've heard, I think we had a mediation conversation many months ago.
Yes.
And there was a situation or scenario whereby the mediator, you're all sat in a room, but at some point one party will be asked to leave.
Yes.
And the mediator will make a few suggestions, or at least hear without fear or favor what this side is saying. So do they encourage a particular emotion or sentiment to come through in order for them to now bring it back later?
Yeah, I think sometimes people, not only the normal human being house, even lawyers sometimes confuse this thing, mediation. What do mediators do? Mediators do a lot. In the mediation process, what the mediator does is to listen first to the parties, do what we call active listening. Most people, when they are listened to psychologically, is a form of healing. It's what we call catharsis. The people become cathartic. By listening to them narrate their conflict, you give them an opportunity to even cure themselves. So the mediator listens to the parties, identifies the issues of concern between the parties, then assists parties to generate options, and then assists them to evaluate those options and come up with solutions that benefit them. So a mediator does a lot in the system, only that mediators never give their own opinion. Mediators don't give suggestions unless people have asked for. You always allow the parties themselves. You assist them by, when people are angry, for example, and when people come to conflict resolution, they're not friends. That's one thing you must know. And therefore, when they talk, their conversations are full of negative connotations. Yeah. So there are a number of things that a mediator does. One, you reframe those statements. You see, one person can make a very derogatory statement. Before the other one responds, you have reframed. Reframing means you detoxify You remove blame, you remove toxins from the statement, and put it in a more user-friendly to the way to the other party. So it prevents them from getting what we call a retaliatory cycle. The retaliatory cycle is a way we start wars, a way we make wars. So a person will make a statement which is a trigger. And before that other person has a perception of a threat, the mediator passes in between to reframe that statement. So the response from the other side will be less toxic, and therefore you are moving them towards agreement. So mediators work hard to move parties from a retaliatory cycle to a conciliatory cycle, and then towards their own solution. And there are so many techniques that mediators use to do that, to get people there. So that's why for a person to become a mediator, you need to undergo
some proper
training. So that apart from reading body language, you also know how to reframe statement, paraphrase statements, partialize, mirror, and do all other stuff to ensure that the conversation, you make people have a meaningful conversation that leads them to their own mutually acceptable solution.
I guess the biggest lesson is how to stay neutral.
Exactly.
Because you listen to them and be like, "Yeah, huyu jamaa, huyu amekosea, huyu mtu lakini." How do you train people to stay neutral, to remain neutral throughout? You are a human being. You'll find that when you are dealing with a person A, party A is, looking like they recognize your presence more. Party B is treating you like, Kwanza, you are just you're part of this whole mess. So you tend to lean to party A, like this guy. How do you train people to remain that neutral?
The issues about neutrality is teaching people about perception. Usually, we look at things differently. For example, if I draw a W here, probably what you'll be seeing is an M yourself. She'll be seeing an E or a 3, depending on what section she is.
She's looking at. She'll see double V.
Yeah. So, all that, none of us here is stupid or crazy. Everybody is right from their own perspective. So what we teach people, first of all, is patience. Trying to understand that in any conflict situation, nobody is wrong. And then we also teach you what we call the conflict dynamics profile, to become conflict competent. People who are conflict competent usually are the people who know how to respond to conflict constructively. If you are conflict incompetent, you respond to conflict destructively. When you are conflict competent, you have conflict intelligence. So whenever something happens, your response is constructive, and therefore you reduce the adverse effects of conflict. This training we do also helps you to understand yourself. There are personalities and temperaments that we teach you about. Personality is always the dress we put on. I'll always behave in a way that pleases you. But temperament is what I'm made of, who I really am. So once you understand who you are yourself, yes, we have our own prejudices, but as a mediator, you are trained to have what we call a prejudice basket, where you close your prejudices and you treat people who are in front of you equally. That's why you cannot shed tears with both people when they are crying. You need to have a hard head, so that when people pour frustrations on you, you are the only person who is stationary. You normalize, validate the pain that people go through, but at the same time, you are assisting them, knowing that these tears that you are seeing have a psychotherapeutic effect in conflict resolution. In fact, they assist people to reduce their emotions so that they can be able to see their conflicts more clearly. So that's why a mediator requires proper training to be able to assist the parties resolve their disputes.
Okay.
Yeah.
What kind of cases are we talking about here that would end up in mediation? Because one would assume, well, we have an issue, one party to the next, and we can just go mediate instead of going through litigation. What would warrant that mediation then is introduced?
As far as I'm concerned, in my 20 years of mediation practice, I know that all cases are mediatable. But there is something that happens in this country. People say you cannot mediate criminal matters.
Yes.
But if you say, I came today with a very nice book, and the topic here is mediating criminal matters. People are mediating criminal matters everywhere. Even our own constitution, if you look at Article 159, 2P, it recognizes 3 ways of resolving disputes. That is mediation, that's litigation, alternative dispute resolution, and traditional dispute resolution mechanisms. And we have had cases that have been mediated and accepted by the court. In fact, if you go to our case law, you will find a case known as Mohamed Abdu versus Republic. In this case, this was in Isiolo. Mohamed Abdu committed murder. He was arrested, and the police were planning to arraign him in court. The two communities sat together, and they said, we pay you 50 camels as blood money. And the people settled. In fact, the father wrote, saw an affidavit to the director of public prosecution, saying they don't need to pursue this case in court. The director of public prosecution withdrew that case under Article 159 2B of the Constitution. And many, many other cases have taken place. There is a notion that we have, and I want to demystify it. Our criminal justice system in this country talks about, we always believe that any offense committed is an offense against the state. And that's why any victim comes to court as a prosecution witness.
Yes.
We assume that once a victim has given evidence and they are discharged and the offender is sent to court, to jail, that's it.
The justice has been served.
No, justice has not been served on the victim. That's why I've always been encouraging people that we have a system we call restorative justice. That's victim-offender mediation. So that we can also give justice to the victim. Assume a case like rape, for example.
Yeah.
Somebody has been raped.
Yeah.
The rapist has been arrested. They have been arraigned in court, sent to prison. The victim comes to court as a witness. Once she has given evidence, or he has given evidence, they are told they are discharged. We punish the offender. What happens to the victim? The victim may not have that process of healing. Because that's very important for them. We have neglected the victim, who is the most important person in this matter.
When you say that, I think what is then introduced is the element of, well, this person has committed a heinous crime and then should be punished.
Exactly.
And without, where is the regard for their emotions? Because they did not think about that when they were committing the crime.
Exactly.
That's where the abhorrence would come from. That why are we thinking about that?
Let me now tell you the truth. We always believe in punishing the offenders. And that's it in Kenya. And this is not even helping the rehabilitation process. In fact, that's why the prison systems have got challenges. In victim-offender mediation, what you do, you prepare the victim. And with their permission, you prepare the offender. And then you prepare a representative of the community. Then you assemble them in a place like this with the permission of the victim. If the offender is in a position to show some kind of remorse and agree to do something like community service, it begins the process of healing for the victim. The offender goes back to prison. They serve their sentence. When they come back, when they are released, they are able to be accepted back to society because the members of the community were involved in this process. You know the reason why people leave prisons, they go to the village and they are rejected because of stigma. It's because members of the community were not involved in this process.
The dispute was not resolved.
And the victim has not healed. That heinous crime is still in the mind of the victim and they are horrified. They are still traumatized. So victim-offender mediation assists a lot to create an environment where we rehabilitate the offender. The process of healing for the victim starts, and the members of the community can accept the offender when they clear off their sentence. And it reduces, in other jurisdictions, it reduces crime a lot.
I see.
Something that we need to look at from a different perspective. Not only punishment resolve this. Punishment only does not solve the process completely.
So you're advocating, if I get you right, for both things to happen.
Yes.
We can go through the litigation process in the criminal justice system, but at the same time, it's important to have the mediation process happening.
For
victim, community, and for the purpose of the victim.
Exactly, to serve the interests of the victim, who is usually forgotten in all this criminal justice system. Victims are forgotten. And these processes have worked in other jurisdictions. We have assisted them work in other jurisdictions in Africa in the first place. And
have they been properly adopted? Give us an example.
In Kenya here, we are still a long way to go. You know, we are very slow in adopting, like mediation. That brings me to the station today. 80% of the Kenyans do not know this thing exists. You know, your TV stations are showing Vioja Mahakamani. So people know that when they have disputes, The best place to go is to go before a judge.
Yes.
That's why somebody can threaten you that I will sell my car and take you to court. We need to do a lot, especially using the press and you, the media, to spread this news. You know, even the Bible says, my people perish because of lack of knowledge. The Bible itself encourages us to resolve our disputes before referring them to the system. We have done very little to pass this message to the members of the community. People cannot even understand the legal system itself. It is expensive. They cannot afford a lawyer. It is traumatizing when you subject these people to things like cross-examination. There are better ways of resolving conflicts, and that is through mediation. The only thing is, we have complicated it. We have made it. People now do not understand what mediation is, and we have also started bringing up other things that are not mediation. The best thing we can do, and I'm just passing this message to those mediators who are in this country, let us take our time, educate the public about mediation, so that even those people who are trained, they may get the business to do. People may not refer their cases to court. We have cases in the insurance industry, which can be mediated, in the manufacturing industry, which can be mediated, employer-employee disputes, which can be mediated, land matters that can be mediated, medical negligence disputes that can be mediated, disputes between employers and unions can be mediated. Mediation is everywhere if we use it well. In fact, some policies in other countries like America, you cannot approach the courts unless you have gone through mediation. In fact, you approach the court and you want to file your case, the court will tell you, have you attempted mediation and failed? Where is the certificate? Where is the report? Then your case can be filed. Until we get there, we have a serious backlog of cases in court. Our judicial officers are very few, they are overwhelmed, and therefore we are compromising the quality of justice in this country. When we have options that can address those issues, reduce the backlog of cases in court, and therefore allow our judges and magistrates to handle fewer cases and therefore improve their efficiency.
Let's take a break. That's a very good point.
Yes.
29 minutes to 8. Our guest this morning for our Justice Thursday conversation is James Mangerere. He is a senior advocate of the High Court and president of the Mediation Training Institute, East Africa. He'll tell us more about the Mediation Training Institute and what they do and how long they've been here, who they're training, and how much money they charge for this and all those issues. After this break, keep it here.
Nairobi.
Okay, so I'm sure everybody has had mediation in one way or another. Alternative dispute resolution mechanisms. We've talked about it very many times on Justice Thursdays. Today we are focusing on mediation and getting to understand deeper, and who better from than the president of the Mediation Training Institute, East Africa, James Mangerere, who's here with us, taking us through this mediation. I just want to ask you as we head into this next one, is a marriage counselor a mediator?
No. They do counseling. Counseling and mediation are two different
things.
Completely.
Okay.
Yes.
It's because you said a mediator is also this person who listens to the warring parties, listens to them and eggs them towards their own solution.
Yes.
Right?
Yes.
So as you're listening to the parties and you're egging them to your own solution, isn't that what marriage counselors do?
Counselors listen so that they can assist parties to heal. It's what we call listening the soul to existence. Mediators go a step further to help people resolve their disputes. Counselors can listen to you, waiting for you to heal. Mediators go ahead and assist you to resolve your dispute so that you can come up with your own practical, mutually acceptable solution that works for both of you. So you come up with a win-win solution. It's a self-determinative process where parties make their own decisions, but a third party has to assist them to do so.
Okay.
Yes.
Would mediation then come in where the state is involved? And these are cases where the state is prosecuting an individual or prosecuting an entity. The state versus where the office of the DPP, for example, is involved. Would mediation come in as an option here?
Yes, of course. You know, even the previous doctors' union dispute in 2017 was resolved through the process of mediation. I have also assisted resolve disputes that involve these state agencies. Even investor state disputes, people coming from outside to invest in this country, most of them do not have the time to go to court. They don't want to subject themselves to the adversarial legal system. So they prefer having their matters mediated because business people themselves, They want to resolve their disputes and maintain their relationships. If you go to court, one side will win, another one will lose, and that relationship will be destroyed. So even state agencies, private institutions, international organizations, they are all, mediation is available to them as a choice, as an alternative way of resolving conflict rather than subjecting themselves to the court process. Yes.
That's for civil cases. How about the criminal cases? Where the director of public prosecutions is involved, like you said, in the case that you've just given us, the state versus so and so.
I have mediated a criminal matter, and it was, most of these matters are confidential. There's an element of confidentiality. I've mediated so many of them, so long as parties were available and ready to do what? To resolve. In fact, some people even say you cannot mediate the gender-based violence disputes. But things like domestic violence, people mediate them every now and then. Sometimes you go before the courts. The courts will make a decision. For example, husband and wife have differed.
Yep.
The husband is working as a watchman or a guard somewhere.
Yep.
They are being paid 10,000 shillings. The court makes a decision to attach that salary so that we can take care of the children and the wife. The guy says, you have attached everything. Why am I working? They resign and they go back to the village. The wife and children are forced to follow the husband to the village to go and do the farming to get something to eat. So what has really the court done? They have made a decision that is not implementable. If you brought these people before the mediator, a mediator will find a win-win solution, a decision that comes from them. We are too slow to accept that we will not always get these resolutions through fights. We believe that we must put up a fight before we get what we want. And that is something that's been ingrained in us since the colonial time. The Mzungu told us that if you want something, you have to fight for it. That's why you see a man in the village saying, I'll sell my cow and take you to court. And when they sell their cow, that's not even sufficient to pay the lawyer and anything. And then in the course of that trial, they get frustrated. And what I always tell people is that nobody wins a court case. And I can prove that.
Nobody wins a court case?
Yes. I have been in court for all those years, and I've seen people go to court. I can give you a very simple example right now. Me and you are neighbors. So you move my land in 5 inches of my piece of land. So I'll take you. You take me to court. You file a suit. You hire a lawyer. Take me to court. So you pay your lawyer. Probably the value of that piece of land, those 5 inches, is about, let's say, 50,000. You have taken me to court. You pay your lawyer. The case takes 2-3 years to resolve because of a number of applications in court. Eventually, you win the case because the judge will say, take that piece of land back to where it was. And then they will award you costs. By that time, the lawyer has spent a lot of money in doing your case. They will give you a fee note, which will consume everything that you have paid. Not only have you spent your money, you have spent your time. There's a lot of trauma in the court system. The vagaries of the court system are not friendly. What about if you call somebody, a third party, and told them, this gentleman has just moved my piece of land. Can we sit down and then we see how we can resolve? A third party comes in and tells you, let's look at the history. Where was your land previously? What is he doing right now at this particular point? Why don't you people agree, get the land back and maintain a good relationship? Because when you have a good relationship, this and that will happen. And they say, let's greet each other. These people will greet each other and their children meet together and that relationship can be destroyed. So if you went to court, you spend that money and you got a judgment. Did you really win that case?
No, you didn't.
So it's just simple. But
enemies.
Let me tell you the problem with going through the courts. You destroy your relationship. You spend money. It's traumatizing. When you go through mediation, first, it's private and confidential because nobody will know what's happening. Number 2, it saves costs. Number 3, it takes less time. Number 4, it preserves the relationship. There are so many advantages that you have in mediation than resorting either to arbitration or the court system. And the sooner the Kenyans realize this, the better for them. We'll have less cases in court. Relationship will be improved. Look at example, succession matters in court. The judge makes a decision that this and that will get the property according to their father's will. They tell the judge, that's what you have just said, but we have another way of doing it at home. When they get at home, each one of them carries a weapon. And they say, this is where the land will be. Forget about what the judge said. So instead of the judge taking people that direction, in fact, the courts these days are encouraging people to go into mediation. Because the decisions made in mediation are easy to implement. Because people tend to respect decisions they have made than decisions
that have been
handed
imposed
down
on
by
them.
a third party who may not understand the culture, the substratum of the dispute. The earlier we realize about this, the better. And I'm asking, I don't know what I'll do to ensure to educate Kenyans that mediation is a better option.
James.
The media will help me, everybody else. We will save Kenyans not only money, but the kind of trauma they go through in trying to resolve their disputes. And we have qualified people in this country who are mediators who can help us manage that and reduce the backlog of cases. You know, judges and magistrates are also human beings. When they go home in the evening, they want to watch TV and play with their children. Why should they carry your file home to go and do your own case? Let's give them easy time. There are cases that mediators can do that should never find their way to court. So Kenyans, let's wake up and smell the coffee.
Our constitution, Kenyans gave themselves a constitution.
Yes.
And Kenyans recognized that there are many ways of resolving disputes. And that's why you even quoted the constitution. You've said we can go to court.
Yes.
We can look at alternative dispute resolution mechanisms.
Yes.
We can go into traditional dispute resolution mechanisms, right? And that's where dispute resolution comes in and mediation.
Yes.
The people who are involved in everyday society, people who are involved in resolving disputes are number one, wazes in the village.
Yes.
Can call them nyumba kumi elders and such. Chief is resolving very many disputes. OCS is resolving very many disputes. You've trained many people. Have you trained any of these people? Have you trained police officers, administration officers, chiefs, assistant county commissioners and such, or even village elders on mediation, on how to understand those things that you're saying? Read body language, stay calm, de-escalate situations, urge people towards coming up with their own solution.
Exactly. In the year 2008, immediately after the post-election violence, we had an MOU with the National Legal Aid and the European Union. And I trained Council of Elders. I went to Kisumu. I trained the Luya, Kisi elders. I was at the Gadamene Hotel in Meru, where I trained the Meru, Empu, Isiolo, Kikuyu leaders. I went to Voi. I trained some leaders there. So, but this was a limited number because it was a total of 75 mediators all over the country. So I expected, these people have done a lot of work in resolving conflicts within the community. I expected that the government will take over and sponsor assist these parties to get trained because community mediators are people who are trained to diffuse tension in the community. Most disputes are resolved at the community level because that process of community mediation is culturally sensitive. We take our culture into account when we're resolving disputes. So I did that. I have also worked with other organizations. I've gone to Samburu. I've trained the Masai Morans over there and the local elders. I have been to Bungoma, I've been to Kilifi. I've gone to areas at the border, even outside this country, trying to train people in what we call village mediation, how they can handle land disputes, family disputes at the village level for people who cannot be able to afford this. So I'm doing my best, but I need help. I'm just a drop in the ocean. I need people, I need organizations to come in. Let's work together and promote mediation in this country. Our chiefs, I've trained a number of chiefs in community mediation. A number of people, police officers. I've also trained other professionals because there are some cases that are technical. For example, if you are doing a construction dispute, you may require an engineer who understands who are subject matter expertise in that field. If you are doing a medical negligence dispute, you need a doctor who understands that technicality of those areas. So I'm trying my best to train doctors, engineers, human resource managers, so that these people, whenever I have a case, I'm a lawyer and I may not understand the technical part of it, I can bring this person as a co-mediator to assist me in understanding the technical issues in that particular area.
Okay.
Well, we have a long way to go.
The Chief Justice, Martha Koome, has the vision, the social transformation through access to justice.
Yes.
And one of the things that she's pushing, and she's said the judiciary is now focusing on, is looking at the alternative dispute resolution mechanisms. That's why court-mandated mediation is actually now a big thing.
Yes.
The alternative justice system courts have been established to help in this. Have mediators and mediation being incorporated into this system such that there is funding for an institution such as yours to train mediators, to have more mediators coming in. We have a judiciary fund. It's not well resourced, but it has 13 billion shillings and counting. Have you had conversations with the judiciary where they say we can actually allocate money towards increasing the number of trained mediators in our community?
You see, first of all, I'd like to commend the judiciary, because if you look at back in 2015, under Justice Tunga, we started the court annex mediation program, pilot program at Milmani Commercial Court. We started with the commercial and family division. And it was very successful, and that's why the courts rolled it down into 13 high courts initially. I'm sure most of the high courts now in the country have got those. We have new rules that came up recently. That's Legal Notice number 145 of 2022 that came in to improve the way we operate in mediation. Now, I will always encourage our courts, especially the court annex mediation, the court annex mediation committee. You know, when you have started something like mediation, I think it is important that we make it a success first. Still, it's work in progress. We need to ensure that our courts improve the efficiency of managing court annex mediation in our courts. We train and look at the quality of the mediators that we bring in the country. I've seen cases of countries like Nigeria and other countries where they really mind about the quality of the mediators they have in the field, because if you have a mediator who's not properly trained, the first instance they have with parties will have a very bad experience, and this will give mediation a bad name. So what we are working on is a mediation bill. We want to have a mediation act in Parliament. The same thing like the Arbitration Act, because mediation is not a small sister to arbitration. Mediation is a discipline of its own. We're working on a draft bill with different stakeholders. This bill has come back to Parliament 2-3 times, and it's been thrown out because it was badly done. We hope this time round the bill that we present before Parliament will pass, because once we have a bill, we can then be able to control this. But in the courts itself, I request those people, those policy makers, that let's get to the level of where other countries are in mediation. Let us promote mediation by ensuring that, first of all, we maintain the quality of standards of mediators. We improve the way we operate mediation in our court next mediation program. In fact, what I didn't tell you is that I'm a board member, I'm a director of the International Mediation Institute, Netherlands. And we mind a lot about standards of practice. So I would like us, because I'm the only African director who is there, and I come from Kenya. In fact, Kenyans, we should be a role model in this field, where people should be looking at quality first. So our courts, let's mind about quality, and also let's improve the efficiency of how we operate court annexed mediation. It needs to grow. We have not, we have not reached. You know, there's something wrong if you can do something and leave it at that particular point, move to another, before you perfect what we already have. Court annexed mediation should be improved, perfected. We get the good quality of mediators in the field so that we can offer quality service to the public. I also encourage private mediation. Now the new rules allow for people to do private mediation. And if there's an agreement, that agreement can be taken to court. It can be converted into a court judgment, which is a very good thing. But be that as it may, we need first of all to improve the quality of court annexed mediation program that we have. And legislation will go. And legislation will really help us a great deal, so that we need to work out a bill that will address issues to do with the quality and management of quality and the standards of practice. Then the other thing, we have a Singapore International Mediation Convention. Kenya has not signed. Uganda signed and ratified that Singapore International Mediation Convention, such that if there are foreigners, especially who have cases in this country, and there is a mediation agreement, can it be implemented outside our jurisdiction? The answer is no, because we have not ratified the Singapore International Mediation Convention. So Uganda has done it. I wonder what we are waiting for, and yet we are qualified mediators in this country who can assist the Attorney General and the government in having this thing placed before us. We talk about it, we discuss about it, sign it, ratify it, so that then international investors can have the confidence of investing in our country, because disputes that arise can be resolved and those agreements that are made can be implemented outside our jurisdiction. So we have a lot of work to do as mediators in this country, and I will ask the private mediators and the judiciary to work in the collaboration. We are all moving the same direction. We want to promote mediation in this country. Why don't we work together to promote that mediation together? Yes, like other countries have done in some parts of Africa.
If we go to the actual cases themselves, how do you then decide that we're going to actually take this to mediation? Let's say that two parties have already started to engage in the via litigation, and they've said, well, you know what, this is an option for us to take this through mediation. What's the process? How do you then say, okay, we've decided and we're going to go to mediation? Do you look for a mediator? Do you speak to counsel? How does it actually happen?
Well, if a case has been filed in court, we have what we call a screening process. Cases are usually screened by the mediation registrar, debit registrar. They are screened, and they have a criteria of screening those cases. Once a case has been identified as being suitable for mediation, and the criteria is they look at the age of the case, whether the case has got pure points of law, that case cannot be referred to mediation, because not all mediators are lawyers. If there is a case that affects public policy, that case cannot be referred to mediation. But if a case is in such a way that it benefits people generally, it can be referred to mediation. Once that screening has been done, the mediation registrar notifies the parties that your case has been identified for mediation. And they ask the parties or their lawyers to file what we call a case summary. Then a mediator is appointed from the list of accredited mediators, and the case is given to a mediator to do for 60 days. Now, parties themselves have the leeway, the discretion to tell the court that we want our case to be done what? To be taken to mediation. And the court will accept, because that's within the laws. And the parties themselves can choose their own mediator from the list of the mediators that are provided for in court. And they can have their matter referred to court. Now, that does not mean that all cases must go to court for them to be mediated. You can still mediate your dispute before you file in court. And the court allows you, if the case has been mediated by a qualified mediator, you can take that agreement before the court. The court will adopt it and convert it into a decree or a judgment of the court. So I'm sure if Kenyans knew this, first, there will be nobody rushing to court. They will first of all want to try mediation. And if by any chance your case is in court, you can still apply to have your case referred to mediation before a mediator of your own choice.
Who certifies mediators in Kenya?
Now, that's also another very interesting thing. For those ones who work in court, specifically, there's a mediation accreditation committee that sets the standards and also interviews and certified mediators. But for private mediators, for example, I want to talk about mediators, Kenyan mediators, mediators trained by MTI, Mediation Training Institute International. Mediation Training Institute International has been certified, accredited by a number of international bodies. We have the International Mediation Institute, Netherlands. So our mediators usually apply, and they are qualified as qualified mediators or IMI. They can use their logo. And once you have practiced for a year and pass, you have done 200 hours of mediation, then you can apply. MTI is a qualifying assessment program for the International Mediation Institute. We can assess you and certify you and send your name to IMI for certification. We are also certified by the Singapore International Mediation Institute, NISIMI. So all our mediators that are trained get that certification. We are also recognized by the International Academy of Mediators, where I sit as a governor in the United States. I sit as a governor in the International Academy of Mediators, who have recognized MTI and its mediators. You are also certified by MTI East Africa and MTI Africa, according to their credentialing program. We have standards of the framework of certification that we have.
Is there a need to have a single qualifying authority in Kenya to say that wherever you've gone to study, the thing you were talking about, standardization.
Yes.
You can study at MTI or any other institute, but in the end, you shall sit a common exam, and there's one entity that gives you proper accreditation as a mediator.
That is the purpose of the PIL that I'm telling you.
Okay.
This PIL will set up those structures which you do not have right now. These days, anybody can train you and give you a certificate, and you'll approach the courts and they'll interview you and accredit you. That itself has messed the standards of practice in this country. Because everybody is a trainer. They come in the field, they tell you, sit down. This guy is asking you 20,000, I'm asking you 6,000, sit in, I teach you. People don't really realize what they are receiving. Is the person who is training you, what mediations have they done? What experience do they have? What's the quality of their program? Where is the certification going to take you? Because our mediators can practice in Nairobi, they can cross over to Europe and practice, they can go to America, to Australia and Canada, and their certification can be recognized because of this peer review and certification that we have with other international organizations. And we have done our best to customize our training to the African setting. Let me tell you, conflict is not the same thing. What is conflict in America may not be conflict over here. We have our training text in customizes in conjunction with our culture. We look at conflict from our cultural lenses. So we train people, like now in America or in Europe, greeting somebody with both arms, people would think it's a useless thing. But you remember when you were a child, what you told you greet hurdles with both arms, isn't it?
Yes.
As a sign of respect.
Yeah.
If you see a mediator doing it in Kenya, it's because they have been trained in such a way that our training reflects our cultural context. So we don't look at the videos that our friends from the West have role played and then customize that. We have written books. Like myself, I've written a number of books. Some of them are on the texts, on the textbook center, on the bookshops. The books I've written, I've tried my best to look at the standards of practice worldwide and customize them using our African context. So if you read our book, it's easier to understand because it reflects our cultural context. And that's the difference. Yeah.
People who are listening and they'd like to reach out to you, for training, for matters, advice on mediation.
Yes.
How would they do that?
Well, this is our website. Our website is www.mtieastafrica.org. If you go to that website, you'll get a lot of information about our training, our certification, our mentorship program. We also have an institution known as the Institute of Chartered Mediators and Conciliators, which is our membership body. It's a credentializing body. Those mediators who have been trained, they are encouraged to be members in that institute. They are recognized worldwide. We have members from Uganda, Tanzania, Rwanda, Burundi, DRC, Congo, Southern Sudan. We are trying to work together to harmonize our practice and also create an environment where you can get your business. So by being a member of the Institute of Chartered Mediators and Conciliators, you get a place where you can meet other mediators, peer review, get business, and grow your mediation practice.
Okay.
That's what we do.
So the message here this morning is, sio kila kitu ni polisi.
Yes.
No, you can actually have a conversation among you two and come up with a solution as you two parties in dispute. And that's where mediation comes in. James Mangerere, Senior Advocate of the High Court of Kenya and President of the Mediation Training Institute of East Africa, has been our guest, teaching us about the importance of mediation and what makes a case appropriate for mediation. 8 a.m. Keep it here for more.
Spice up your life